Deputy Attorney General Justice Ramsay say, hey, there is miracles, braha. Onu will be also nan saying, EOCO for granted bill, look what I say, perfect, say, EOCO for I interrogate you on any 55 million Ghana cedis. Also, we are true. I am true. No one tells us Ghana for company, just as in the dear. Justice Ramsay, which are in common, was that the massive update about oral, or to share big cases, and Jibiamo. I think you'll enjoy this episode. Nyabo Trinity start to tea. Maninkusi Menskepe. Na Attorney General, na Deputy Attorney General, Justice Ramsay, fire back at Dennis Miracles. What's Ghana for? Attorney Biam, Sabi, Mumiyami, and Inaho. Nabusia, what can be for bail condition? Unse MPP for him be say about when the bail condition punish him amufono. Nano, and a Deputy Attorney General, Justice Ramsay, I think I was fully convinced, sure. I say bail no amount to a setting. Any 2-3 a bail condition. I was say any offense no eko benkrobo kakra. What you say? Because ultimately go we are 10 cedis. Na say bail condition 1 cedi. Say they obey me amobi just 1 cedi to raise the property to the tune of 1 cedi. They grant you bail. And the emprempi no bonena you've been accused allegedly said what you know. A ho sa amount no and they setting the bail condition around. Abusia, I think this updates Ebe radio on Soka to show. Message or subscribe. We are now what bell notification icon. The video no drop here. So feel free to leave your comment in the comment section. Or share link in enough for any be a share. Me patch little flower green clean solutions and they go so ya to answer for sana pay. We are enumere. Patch ya what me kabia. Friend no best ne go screens wati. Na afide any me di juma. You be say you hospital church bank institution. I sorry demo. I'm how kama. Me can pa we enumere because emprem baby obi tie na samre anopa. Some maybe a numerous some area or be crum. It's Abusia, you ever trying to pull at the amount you were just over a crana over Kumasia. I just a traffic light or tire pet or said if I sabotage 1 2. I say, oh, pay was Sabak. I know if you Kumasa so quite crowd drew. I just a traffic light now on Sabin Kums, I sabotage 1 2. I say, oh, pay once ever kind. Very natural backups about able to menstrual pains, any abdominal pains as in budget for ultimate car for numbers in the screens on the Kojibi. Na NCC wa him feel. Deputy Attorney General Justice Ramsay said there is miracles, braha. Na so could in trobi or by exposing.
Also gets a bit. You see, the bail issue. Bail is based on a number of factors. The nature of the crime, okay, is one of such factors. Even the accused person's behavior, past, present, or likely behavior, they're all part of it. Okay. If you are investigating someone who has stolen 10 cedis, and then you put the bail to 1 cedi, the person is likely to break the bail and pay 1 cedi or get someone to pay the 1 cedi. So usually the bail is measured based on the nature of the offense. In, I think, this Sagleby, the bail condition that was as at 2021 or 2022 was running into how many millions, hundreds of millions of because of the nature of the subject matter. So I think people use their personal circumstances. So if you say someone's bail condition is 50 million, and then I look at myself and say, oh, I have never seen 10 million before. So how are you asking someone to use 50 million to put bail? But the truth is, the person maybe is being accused of stealing 500 million. So they always need to match what is at stake and the bail terms. Of course, I am not oblivious of the fact that there are situations where bail is quite excessive. But even then, courts have given bail conditions which accused persons have not been able to satisfy because of the same problem. If you are accused of something, you need to get people to come and bail you. It's people's willingness to bail you that determines what should happen. Someone cannot satisfy bail condition of 1 million. Another person can satisfy 50 million, 500 million. It's all about variances. So again, when you run the facts, you will see that it is not really true, especially when it comes to EOCO. I think there's this narrative that EOCO has been using the bill, but when you
can you blame people when they think that?
No, I'm saying that, you see, you are a media person and you know how narrative can create perception, and the perception can become a belief. EOCO grants bail, And sometimes when we go to court, the court even give higher bail conditions to the person. So when you look at those things, you realize that it is not even truly, it's not correct that EOCO give excessive bail, because EOCO gives a bail and you expect that, okay, we all believe that at least the principle of the court will be fairer than, but the courts give even sometimes higher bail condition than EOCO in respect of the same person.
We have also seen instances where the bail will only be given in last minute.
And let me ask you, there are accused persons, okay, who would, during the interrogation, they prefer EOCO bail condition to going to court. If I told you, you won't believe, but the accused person, when you say, let's go to court, they say, no, we are working on it, They don't even want to go to court for that bail situation. And about the lateness.
The last minute bail that is given.
No, see, again, there is nothing like last minute bail. The Constitution is clear that you cannot hold someone beyond 48 hours, right? So when you come to, when it's 48 hours, the 48 hour is the red line that you don't cross. So anytime you are getting to 48 hours, you know that you are running out of time.
Then we give bail at a point when the person cannot bail themselves.
No, you see, when they give you bail at that time, the law doesn't say that you shouldn't be taken to court until you satisfy it. You are always available. I mean, the court is 48 hours. 48 hours, you should be before a court of law. So, I don't know how else to explain this, but the point I'm trying to make is that...
What I want you to address is, person A is taken in by this investigative agency or law enforcement agency.
Yes.
And for 36 hours, they have been there. 47th hour, they grant the person bail. By 48th hour, you haven't been able to
yes, that is what I'm
meet
saying.
your bail conditions.
That is what I'm saying, that when it's 48 hours, it has nothing to do whether you have been able to meet it or not. You are supposed to be sent to a court.
To court.
That is the position of the law. And no one can dispute that. So it is not, the 48 hours is not dependent on whether you have been. So when they give you bail, and I want the public to be aware of this, okay?
Right.
When they give you bail condition, you are not bound to satisfy the investigator's bail condition. You are entitled to be sent to a court for the court to determine the bail. But I just told you that some accused persons said they don't want to go to court. It's because sometimes they know that when they go to court, the bail condition may even be worse or may be unfavorable. So they will prefer, let's remain here and find a way to sort it out. And you see, a lot of things happen which we law enforcement people cannot put out there. You keep someone, you give someone condition, you want to take the person to court, oh, I'm working on it, hold on. The same person goes out and says, hey, they've kept me for more than 48 hours. When that 48-hour delay is his own request. So a lot of things happen. So my caution is that we should not treat the reports of persons who have gone into detention and are out and are saying something else. Recently, what's his name? Miracles. He came out to say that nobody questioned him about 55 million, that it was questionable. And people believe that. People believe that. Because Miracle is saying it, everybody believes that that is the truth. And nobody is even interested in asking EOCO, how do you even conclude that is true? And you see, EOCO is not under any obligation to be responding to things like that. Law enforcement, we are not under any obligation. At the end of the day, we will bring you to court. We will charge you. You will have your day. So whether we ask you about 55 or we ask you about 5, it's not even our headache. Eventually, whatever we find on you, we'll bring it to court. At that point, we have had situations where people have said nothing. In the end, did they not say that they want plea bargaining? When they said no, we came back, they just kept us and they didn't ask us any question. But the moment they are charged, they said they want plea bargaining. So I want the public to understand that law enforcement, because of the nature of the work we do and because it's investigation, it's not everything that law enforcement can respond to. But that doesn't also mean that lack of responding to some of these things means that the person who is saying it is right or is correct. That's all I want the public to just be very aware of that.
Is Dennis wrong in that when he
Oh,
says
of course, he's completely wrong. I mean, you cannot say that it was no question about 55. Completely wrong.
Was he questioned on the 55 minutes?
Yes.
I see. So he's very much aware of why he
Oh.
was kept in there.
Let's not even go further. He's very much aware.
It's the first instance of Justice Ramsay and on a fay oral cases massive updates. Adu-Boahene update aba. Samson Adu-Wahab Hanan also update aba. And I'm for Justice Ramsay reveal say big cases be and I'm kwamu eba. Na ne de by ni
So there are, as you know, there are a number of cases that we are prosecuting now, and a lot more still undergoing investigations. When it comes to, so we have SkyTrain.
Yeah.
SkyTrain, we have closed our case. That's prosecution. We closed our case. The defense, as they are supposed to, the two accused persons are supposed to file their witness statements if they wish to. They were supposed to file it. The deadline was yesterday. As of this morning, they have not filed anything. Maybe they will file today. Maybe they won't file anything at all. But we are going back to court tomorrow to conduct case management conference. So when they come to court, they will probably show why they've not filed. That is if they are interested in filing, because you are not, as an accused person, you are not bound to file anything. You can just come to the box and sit down for the judge to make a determination. So we don't know what the reason for not filing is. So that's SkyTrain. We have Hanan, which has been quite dramatic over the week. That's last week and this week, because after the accused person, the first accused person was given a leave to travel, we discovered facts which suggested that he is more of a flight risk at the time of his departure than he was when the judge made a decision to allow him to go. For example, we found out the number of luggages he was carrying with him, everything, the fact that he attempted to also go to the bank and to clean his account.
You're referring to when he was taking the trip to the UK?
Yes, and all that, yeah, and the number of luggages he was carrying also. So we suspected that he constituted more of a flight risk than he was when the judge...
His counsel has said he wasn't trying to empty his bank account. So how did prosecution come to that conclusion?
Naturally, what would you expect the counsel to say? To say that, yes, my client was having to clean his account. We know that he's aware that there's a freezing order on the account. And he took steps to convince the... We don't work at the bank. It was his own bankers who alerted us that, hey, there's something going on here that we don't think is... That is how come we got to know, and that's how come we took the steps. So it wasn't as if we were just nosing around. No, we were sitting and his bankers called us that this is what they believe was going on. And we took the necessary steps.
So he was trying to withdraw from the account or clear the bank account?
Our suspicion, of course, he has not cleared the account. So we can only say that it was an attempt to, because the bank stopped. They did not, comply with his request, and then they called us in. So we can only say that it was an attempt, or we believe that it was an attempt. Not that he cleared it, of course, he didn't clear it.
So subsequently he was arrested as a result of that attempt to travel outside the country and then clear his bank account. Then the matter went to court. And then he was then given, allowed to travel.
The court did not allow him to go. It was simple. The court gave him a timeline to travel. By the time we went back to court, the timeline had lapsed. So that was it. There was no other application to leave, and that was not granted anyway. It wasn't even made in the first place for it to be granted. So that report is completely false.
So it's not true that he went to court after they were asking that you produce him, but you remember that
nobody asked that we produce him. Nobody directed us to produce anyone.
The counsel for Hanan had not gone to court asking that his client...
Yeah, he asked, but we were not asked to produce him. The court said there was no merit, and then it was dismissed.
Right, so that's what I'm referring to, because even before then, the court took a decision on that. I think that he had been released already, and so then they withdrew that.
They withdrew their application the previous day, and then they filed two applications. But I mean, the points in summary there was no order for anyone to produce him because he was already
out.
Yes, he was already out. Yeah.
And so that's the point I'm making.
Oh, you want us to go? I thought we were going to end by saying that there was no need to go into the details. But if you want us to go into the details, we can go. But I don't think that's what you want to use the time for.
No, we are not going into the details. It's just that some issues that have come up in that we want you to address.
Asking, okay, you want us to go into
just like the Hanan issue. I didn't ask you anything about SkyTrain because there haven't been any controversial matters on SkyTrain. But in this particular one, there have been a couple of controversial issues, including what we are just talking about.
Yes, and I'm saying that, you want me to give you the details of what happened, or you want us to just, because I didn't think it was a major issue. You wanted to know the status of the case.
Oh.
But if you want us to do a detailed, I don't know how much time you have, but I can.
Whatever details you can share with us, we'll take.
I don't think it will be a good use of your time because it didn't affect anything. What is happening now is that we are here to start.
But I know you say it didn't affect anything, but then the story is being couched to impact the use of the Attorney General's powers in this case. If you have paid attention to the commentary
from January 2025. We have not, every person that we have arrested, the same allegation is made that we are using state power. So perhaps if we want to follow that narrative, then we don't even have to invite anyone, we don't have to arrest anyone, we just have to let anyone that we suspect of committing a crime to be working. That's why I said that when you follow the minority and the MPP and the narrative, and you run it through the facts, you will see that basically what they are saying is that never invite anybody, never arrest anybody, allow everybody to be working and do whatever they like, because not even one person have you arrested that they didn't make the same allegation. So I don't think that Ghanaians, that fact is lost on Ghanaians, that it is the natural response that they have to everything. They will say you are using state power to arrest enemies. They will say you are using the courts to jail enemies, persecution, political. The same thing in respect of everything. Even when the person said, I am pleading, I want to do plea bargain, they will still say that you are using the state. So the person you are fighting for said, I want to do plea bargain. Of course, that's not to say that plea bargain means that you are guilty, but if you know you are not, why are you going to? So the point I'm trying to make is that we cannot base our national life entirely on the narrative that we are using the state power to. We've had kind of Kenoforiata issue that we are dealing with. We've had Sedina issue. Mm-hmm. So you will be an irresponsible Attorney General when there's a bank calls you, gives you information, you did your check, and then you say because of what people will say that you are using state power, so you allow the person to go, and when the person goes and doesn't come back, you think the Ghanaians who gave you power, who gave you a mandate to govern this country, will be happy that because of your fear that they will say you are using the power that you have been given legitimately, you have allowed someone to travel out of the country who cannot come back or who will not come back, and you use Ghanaian taxpayers' money to now be engaged in foreign countries and to get extradition. Of what wisdom would you be boasting of as an Attorney General or any government official if this is what you are doing? So
the states had reasonable, not
suspicions,
but you had reasonable suspicion.
Yes,
that Hanan was traveling not to go and see his ophthalmologist, but to escape justice.
It could be that he will see his ophthalmologist, but the core issue is not whether he will see him or not. The core issue is, we call it flight risk.
Okay.
What is the level of risk? So we do analysis. This person, is it likely to come back? You know, a lot of Ghanaians or some Ghanaians are familiar with visa. When you are going for visa, they will say this person is not likely to come back. It is not. It may be true that he will go and come back, but they are just saying that when we look at all these factors, you fall within a category of persons who, when they travel, are not likely to come back. That's what the visa people use. So there's a whole analysis that.
So was he already on a no-flight list?
Yes, he was on the stop list. So what the court did when they applied to go to do the medical, we considered the court considered and said he can go. Then after he was given the leave, then he now decided to do these things that I mentioned, which made him in our view, a more likely person not to return than he was when the court made a decision. And that is a normal thing. If the court grants you bail, okay, it grants you bail right now, go and come to court, and you go and commit another offense, or you go out there and you are going to interfere with evidence, the court will revoke the bail and put you. So it is a normal, it's not anything new, it is the normal thing that the courts, that happens in the courts.
Let's move away from that, because there are other oral cases that you've been looking
at. So then after that, there's Adu-Boahene. Adu-Boahene, our fourth witness, is in the box, and we hope that by this week or next week, it would have been discharged. When that happens, then when he's discharged, it means that we have closed our case, and then the accused person will finally be given the opportunity to come and mount his defense, because over the period, at least we can identify about 3 or 4 defenses that he has been trying to put across, which makes the whole case quite interesting, because at the point, we believe they were saying that they actually bought the equipment and that the equipment is there. Then at a point, they seem to be saying that the money was a loan that the accused person gave and that he was taking it back. At a point, he even published a list of politicians that he said he gave the money to help in their campaign. And then at a point, they said it was so, and all these explanations are contradictory. If the money was used to buy the equipment, then it cannot be the money that you used to sponsor the politicians. Then it cannot be loan that you were taking back from the company. Then, so I find it fascinating that this is the kind of explanation that I've been given so far at the first half of the case. Recently, there was an issue also of they made a request for disclosures on the source of money in the government bank accounts. And then we said we do not have any information about the source of the money before it came to the government bank account. And there was this whole issue about, if you don't know about the source, then you cannot know what it is. And I find it quite interesting, fascinating, because any money in any government bank account is for the government. And if you are prosecuting someone from stealing government money, you don't need to go and find out whether the money came from taxes or from foreign loans or from the sale of natural resources, or however the money came into a government bank account. It's of no moment. Once the money enters the government account, it is government money. And to take it out, you need to follow certain procedures. It is the lack of that procedure which is constituting the stealing. The accused person took money from government accounts, okay, and put it in a private account, and immediately within 6 months spent it on specific things. We have put all that evidence before the court, right? So I, in my mind, have no doubts whatsoever that these things, it's not a very complicated issue. You asking us how the money came to be government money is of no moment to the issue. If you are in secondary school and you overpay your fees, do you say because you overpaid your fees, you go and take you go to the business office and you take money and put it in your pocket and say, because I overpaid my fees? Right. You have to follow procedure to get a refund. So no matter how you think the money entered the account, once it's in the account, it's government money. And unless you follow that procedure to collect the money back, there's no basis for what we are saying. But again, I have observed that when you are prosecuting, and this is my first time being a prosecutor, so when you're prosecuting, especially these highly sensitive cases, there are people who constitute themselves into departments of misinformation. They try to do everything to make sure that either they put the judge into disrepute, or they put the lawyers into disrepute, or they put the facts into disrepute, so as to blind the public and create a certain narrative. But we are very focused. We have done our investigations, we have our facts which we have put before the court, and we will not allow any department of misinformation or disinformation to confuse us or the court.
Very well. How many of the oral cases are we prosecuting now in total?
I think we have think we are between 5 and 10 now.
5 and 10.
Advanced stages.
At varied stages.
Yeah.
Of prosecution.
Advanced stages of.
Okay.
Yeah.
Oh, very well. And how many in total are in your report?
When we analyzed the report, I think we had about 30 cases that we thought
Were prosecutable.
Yeah,
so we are looking at like a third of them being prosecuted now.
Yeah, we have other dockets already, but we are going to start with them either during the vacation, the legal vacation. We are going to start new cases.
Another cases.
Yeah.
Which brings me to the question on what we should.
You know what we have done. We are going to continue prosecuting. As far as the oral is concerned, we are going to do it.
Any big case coming up?
Oh, let me just hold on to that.
Why?
There will be other cases. When we're working, we don't actually focus on which one is big or which one is that. We focus on which one is prosecutable. But I can tell you there will be some interesting cases coming soon.
I see.
Yeah.
Let's look at
Deputy Attorney General Justice Rem sign abusafo motin in comedy program na AC radio so katwa show enti the big man himself Nana Kojo Janta mo betin in radio so katwa show mo so for Steve Zandoni makramo